Everyone, let's get started. If we start on time, we try to finish on time.
Sound like John Parker.
I know. I'm opening the hearing on House Bill 2326, and Natalie will let us know what this is all about.
Thank you, Mr. Chairman. House Bill 2326 extends the expiration date for the Scrap Metal Theft Reduction Act, and it also clarifies that catalytic converters are covered by the act. Section 1 amends KSA 56109. That's the definition section that's used throughout the Scrap Metal Theft Reduction Act. And you'll see there at the bottom, we're clarifying that the term, quote, regulated scrap metal does include catalytic converters. And then in section 2, we're amending KSA 56112D. That statute currently provides that the entire act will expire on July 1st of 2023. And so this bill would propose to have that act expire on July 1st of 2028. And I can take any questions.
Natalie, why does it feel like Groundhog Day around here? Every day we hear the same things. Anyway, any real questions, committee? Saying none, thank you. I have a couple of proponents listed. First listed is Detective Fusel on WebEx. So he can correct me.
Yeah, it's Fussell just like Russell.
Okay, that's what I thought, but I'd never seen that before.
Oh, that's fine, sir. Well, good afternoon, Chairman and Committee. I'm Detective Fussell with the Wichita Police Department, speaking on behalf of the City of Wichita. I'm here today to provide testimony on the passage of House Bill 2326, which further defines catalytic converters and extends the sunset of the Scrap Metal Theft Reduction Act. Currently, my assignment is with the Property Crimes section, where I've had the opportunity to investigate property thefts involving catalytic converters and other regulated scrap materials. I've seen firsthand the impact that catalytic converter theft has had on businesses who have been repeatedly targeted and individuals who are unable to repair their vehicle due to financial hardship. In some cases, repairing a vehicle can cost thousands of dollars. Looking back at the past several years, Wichita has seen thefts of catalytic converters on the rise. To give you some examples, in 2020, we saw a total of 541 reports of catalytic converter theft, and just 2 years later, in 2022, we had 1,123 reports of converter theft. It doubled. So you may be asking, what causes this increase? Well, for one, the value of the precious metals. Supply and demand issues due to COVID closures caused several of these metals to rise during that time. To give you an example, rhodium, which is one of those metals, rose to almost $29,000 per ounce in April of 2021. Comparatively, in 2019, before COVID, rhodium was only $5,000 per ounce. Right now, we're sitting at about $12,000 per ounce for that metal. Another reason is the low risk first reward. These things are easy to steal. I've personally seen videos of people crawling under vehicles and having a converter off in less than 60 seconds. It's quick, and also it's a target-rich environment. People have figured out which converters have the most value to them. And what do we have in Wichita is several hundreds, if not a million cars driving around in Wichita. So it's easy to find these vehicles to target. Solvability on these cases can be difficult. Converters don't have any type of unique markings unless owner applies those markings to them. And most converters can actually fit a series of different types of vehicles. And lastly, this is a pretty lucrative market. It's actually been talked about as like the modern day gold rush. Depending on the type of the converter and the material content, a seller to the scrapyard can make anywhere from $100 to upwards of $1,000 per converter. On one recycler ticket that I saw previously, I had a subject selling 4 converters and he made $1,600 cash. We know that even some individuals here in Wichita are making millions of dollars for the sell and trade of converters. So in the fall of 2022, the city of Wichita recognized the need to combat this epidemic, and we implemented a law to reduce catalytic converter theft. The law, simply put, just made it illegal to possess a catalytic converter in the city of Wichita if you didn't meet the exceptions of this ordinance. Some of the exceptions such as having a scrap license issued by the Kansas Attorney General's office, or by demonstrating some type of ownership, either through like a bill of sale, a court order, or a service order, would be required to prove the legality of having it. So far, since this has been implemented, we've seen some promising results in reduction. Another way that we've worked to decrease catalytic converter theft is through police investigations using the ks.gov database, which is what we're talking about today. I personally, on numerous occasions, have used the requirements of the Scrap Metal Theft Reduction Act and the ks.gov database to investigate cases. To give you one example, I was assigned 2 cases involving a suspect vehicle. It was the same suspect vehicle and it had the same tag on it. I had 2 witnesses that saw this vehicle. We didn't have a good idea on the suspect at that point. When we ran the tag, it came back to an elderly female that actually turned out to be deceased. If that's all we had at that point, this case would have been pretty difficult to figure out who was driving the vehicle at that time. Luckily, we had the ks.gov program and we were able to put in this vehicle information and run the search on the vehicle. It generated a lead for us. We had 2 individuals that were using this vehicle to bring in converters to a local scrapyard here in Wichita. Working with this scrapyard, they followed the House bill by providing us with the signed tickets of the person saying the property wasn't stolen. They had photographs of the converters. They had pictures of their licenses. They also had copies of the bill of sale. They went a step further and even a picture of the vehicle. So it definitely helped in the aiding of our case. We learned that during the course of 1 month, these 2 individuals had sold 40 converters to this scrapyard for a total value of $13,355. It's quite a month. That's a good paycheck for just a month's worth of work. These suspects were ultimately interviewed, and we were able to charge them with felony crimes through our Sedgwick County District Attorney's Office. Because of this, we believe adding clarification on catalytic converters would help ensure all scrap metal recyclers are reporting this material like the scrap yard in this case did to ks.gov in a consistent fashion. Also, by extending the sunset, this will allow law enforcement to continue to use this database and information that the scrap metal recyclers collect to further investigate and assist victims of theft. The Wichita Police Department supports House Bill 2326. We ask the committee to recommend the bill favorably for passage. Thank you for your time and consideration, and if anybody has any questions.
Very good. Thank you. Questions,
Thank you.
Representative Smith?
Thank you, Mr. Chair. Detective, I just want to corroborate what you've said here. Just 4 days ago in my little old rural sheriff's department, 2 of our deputies was on duty and caught a van sitting in the back of the truck stop right next to a tow building. We ended up solving dozens of catalytic converters off of that conversation they had with those 2 in there. The guy said that what they do is they look at a Google map and they look for collections of vehicles, and they'll then look within 15 minutes of that area to see if there's another one. That's a target rich environment for them. And I only bring that up because this is not just a Wichita problem. It's not a big city problem. They're going out and they're fleshing out, and they're working with other groups, by the way. This is a coordinated effort. This is big business. $400 a pop. In fact, he said, I feel bad about it. I know what I'm forcing these people into when I do this, but I cannot make $400 in 30 seconds anywhere else. And that's what it boils down to. Thank you, Detective.
Any other questions? Representative Carmichael.
Thank you, Mr. Chairman. I think I have 3 inquiries today. First, Detective Fussell, as I think you and I have probably discussed this topic before, and I know I've had multiple meetings with folks from the police department over the years regarding this. As I recall, the Wichita Police Department did implement a program of tagging catalytic converters to try to be able to identify where they came from. I think that was a year or 2 ago. Is my memory correct? And I'm not saying it's a substitute for this bill, but I'd be interested to know what, if any, success that program has had.
Yeah, I know we did do a big public outreach where we had, I think we had several thousand kits, but we only had about 400 people, I believe, that showed up to get these vehicles marked specially. As far as cases that have come up, we haven't seen any of those show up at a scrapyard yet. It hasn't been necessarily successful.
In addition, I know that I had encouraged the former chief to set up some sting operations to try to purchase some of these from the people who are stealing them. And I think that that has been done and perhaps met with some success. Can you update me on that?
I know there was some in the past. Since I've been up here, I haven't been part of any of those. It's mostly been intel sharing. We get a lot of intel from like Crime Stoppers and things like that, that we've actually been able to confirm some of that information that's come through Crime Stoppers by using this this case scrap program to see that they're bringing in this material.
So those operations, and I don't mean for you to reveal investigative techniques, et cetera, but as a general proposition, it doesn't appear the police department is actively pursuing that aspect at this time. Is that correct?
That's correct. Yeah, it's pretty resource intensive right now. We're limited on resources, so we're doing what we can with what we have.
I understand. At the time this legislation was passed, I very, very reluctantly, late one afternoon, and Chairman Barker's committee went ahead and voted for it. And I have come to regret it because of my perception of the number of small businesses that were put out of business. Do you have any information concerning how many registered scrap dealers there are in Sedgwick County now, as opposed to how many there were at the outset of the program?
No, sir, I don't have those numbers for you.
No,
If
the
I recall,
anecdotal.
though,
Go ahead, please.
I apologize, sir. I do know that Wichita has the largest base of scrapyard license holders in the state of Kansas, but I don't have that specific number for you.
I know that anecdotally, the newspaper has reported about acquisition of longtime family businesses that have been in the scrap business for one of them, I think, since 1924, if I recall correctly, that was bought out by Big Scrap and then closed down within weeks thereafter. Do you know whether there has been a decrease in the number of scrap metal dealers that are in the Wichita area now, or has it remained constant, or do you know?
I actually believe it's increased because I know the AG's office, whenever they learn that somebody needs to have a scrap license because they're purchasing scrap material, that they have to get a license. Uh, During some of my investigations with catalytic converters, we've seen a lot of people that are purchasing several hundreds of these that didn't have a scrap license. And so essentially, I guess you could say I was sort of a bird dog on this to let the AG's office know that, hey, these people are buying a lot of material. So they would send them a request that, hey, you need to get a scrap license because you're purchasing scrap material. So we have seen an increase. I wouldn't necessarily call them big companies like you would see like with the Cornejos or All Metal or anything like that. They're smaller companies.
And the AG maintains that registry?
Yes, sir. And it's available on their website.
Okay, that's where I was leading. Final thing is, at the time we originally passed this legislation, there were concerns expressed that the true effect of the legislation would be to put Kansas businesses out of business, and that people who were engaging in scrap metal theft in general would load up their pickup truck in Wichita and head to Oklahoma. And I've seen that myself literally happen. Do we have any idea what's going on with the interstate transportation of scrap? And is that in fact happening, that people who at one time were selling to the local merchants are now headed across the border?
I can tell you from what I've seen, just from looking at the scrap database, that we're seeing a lot of people actually coming into Wichita to bring material. I've seen people from like Winfield, Arc City that are coming in here to actually sell. As far as like going over state lines, I don't have those kinds of numbers for you.
I think the reason that people are coming from the smaller communities into Wichita is because their local scrap metal dealers were put out of business by this legislation. Do you know whether that's true or not?
I can't confirm that now.
Okay. Detective, I appreciate your help and patience with my questions. I'm not trying to say we don't need the legislation, but I've been concerned about its implementation and the impact that it's had on small businesses in my community. Thank you.
Any
Thank you,
other questions
Representative.
for the detective? Representative Humphreys.
Thank you, Mr. Chairman. So just a quick question for the proponent. Besides extending the act, you mentioned that you had, kind of explained the evidence that you found when they knew that someone had stolen or they sold the catalytic converters. And so did they not, are catalytic converters now not included in this? And we feel the need to specifically include it, but it seems like maybe they already had that because you were able to solve that case. So just kind of the need on adding this particular piece.
Yeah, so here in Wichita, we see a lot of people with the scrapyards that are reporting catalytic converters. From my discussions with other people from around the state, some of these other scrapyards aren't particularly like reporting it because it's not specifically defined in this House bill. And so I think that's the thing, to just get all the scrapyards to be consistent with their reporting. Because I think if we're not listing this specifically, that this has to be reported, there's going to be a loophole to that system, and they're not going to report.
Okay, that makes sense. Thank you. Thank you, Mr.
Not seeing any other questions. Thank you, sir. We'll move on to Robert Jacobs. Two days in a row.
It's crazy. Good afternoon, Chairman Patton and members of the committee. My name is Robert Jacobs. I am the Executive Officer at the Kansas Bureau of Investigation. I appreciate the opportunity to come in support of House Bill 2326 and discuss the Scrap Metal Theft Repository Reduction Act. This act, along with the Scrap Metal Repository, which is maintained by the KBI, as has been previously mentioned, is a valuable law enforcement tool for looking and stopping or helping to reduce the theft of scrap metal, specifically catalytic converters, across the state. In 2020, the KBI began collecting information from scrap metal dealers on scrap metal being sold to those dealers. Since the beginning, since in 2020, we have received over 422,000 transactions that were sent in by scrap metal dealers. And we currently have over 9.6 million items of scrap metal listed in our database. This database is valuable because law enforcement can actually go in and query that database to look, as the former conferee mentioned, look at vehicles and particular individuals' names. We have a whole list of information that we get on every transaction. They can search that database to see if those people are doing multiple transactions, not only within a community, but throughout the whole state. Furthermore, the catalytic converters are especially a problem because, as he mentioned, they have precious metals in them, specifically 3 precious metals that the prices have gone up and up, and the demand for catalytic converters, or the theft of catalytic converters, has also gone up across the state. The KBI does support the inclusion of a definition for catalytic converters in there. We just discussed that. I think it is important to define that. The next, another conferee is going to explain that to further detail. I don't want to steal his thunder. So, but finally, we just believe also, because this bill does look at extending the sunset for this law, we think that would be beneficial to continue the use of this tool for law enforcement in trying to reduce catalytic converter and precious metal thefts across the state. And I'd be happy to stand for questions.
Any questions? Okay, thank you.
Thank you.
I only have written proponents listed, but I am guessing we have someone else here that we didn't. Oh, Ed, come on up. It's floating around in the internet somewhere. We'll get it.
Okay.
Resend it when you have a minute, and we'll have Kathy get it out to us.
My name is Ed Klump, and I'm here representing the Kansas Sheriff's Association, Kansas Association of Chiefs of Police, and Kansas Peace Officers. This is an important piece of legislation for us. It's one that we listed on our association's priorities this year. Pretty much been explained what it does. The core amendments, the substantive amendments, are on page 2, line 1, and page 2, line 24. A little bit of additional data, information. Right now, there are 165 investigators across the state who utilize the Kansas scrap metal database at the KBI. And in 2022, there was a total of 4,757 queries by law enforcement into that database. So it is getting used pretty extensively. That number is up 400% from 2021, which was the first full year we had it in place. And as you know, it takes a while for people to learn about it and get signed up to use it and learn how to use it and stuff. And so there was a significant increase there. We talked about adding the catalytic converter. A little more information on why that's important. You might remember that a couple of years ago, I forget which year exactly, there was an attorney general's opinion about whether or not catalytic converters were included in this act. There was debate, and there was scrap metal dealers that thought it was, scrap metal dealers thought it wasn't. And so we sought an attorney general's opinion, and he opined that it was included because of the precious metals that were contained inside. However, we still have people that say, well, that's just an attorney general's opinion. It's not law. And so that's why it's important that we go ahead and add the term catalytic converter in this, make it crystal clear it is subject to the act, and the scrap metal dealers are supposed to be collecting and reporting the information on that. We do have a request for the amendment, and when we find my testimony, and maybe that's an error on my part, Kathy, I don't know, but I'll send it again and make sure you have it. But we do make a request for an amendment to add a definition of catalytic converter. This is pretty important, and this definition that we're recommending here is the one out of the Wichita ordinance, and so we know it works. But the reason it's important is because trucks, large trucks, diesel trucks, semis, use what's called a diesel particulate filter. Same thing, just a different name, and a lot more money. And so by doing this definition, it describes what a catalytic converter device does and defines it that way, so it would cover these devices as well. I'm afraid if we just use the term catalytic converter, then we're going to have people say, well, the diesel particulate filters aren't included. And so that is a request that we have for an amendment. And I think that pretty well is everything I can add to the conversation. I'll be glad to answer questions.
Any questions? Representative Osman.
Thank you, Mr. Chair. Just curious. So we've heard so much about catalytic converter thefts, but I'm kind of curious about the flip side. Like, how often, if you could hazard a guess, how often are people going to scrap yards to give a catalytic converter that they have not received through illegal means?
I would not have that data, but catalytic converters have a pretty long life if you don't cut them off the car, and so it's not an item that is replaced frequently. And so I can see where maybe one might get damaged. If you run over something in the roadway, one could possibly get damaged or something like that. But it's not a routinely replaced item, is my understanding.
Any other questions? Okay, thanks, Ed. Committee, we have written proponent testimony from the Kansas Cooperative Council, the National Insurance Crime Bureau, and the Kansas Automobile Dealers Association. Any other proponents? Don't have listed any neutral or opponents. Are there any of those? Okay, close hearing on House Bill 2023. Open the hearing on House Bill 2381 and have Jesse give us an overview.
Thank you, Mr. Chair. Good afternoon. House Committee on Judiciary. I'm Jesse from the Revisor's Office. So this is House Bill 2381. What House Bill 2381 does is it proposes establishing an appointed attorney for a child who is a subject in a child in need of care proceeding. So it amends a statute that currently allows for the appointment of a guardian ad litem. So in this section, the court is directed to appoint an attorney when the petition for the child is filed, That attorney shall serve as counsel and represent that child. And it has a caveat that if the child's unable to direct that representation or they lack the capacity to do so, the language states that the attorney shall determine what the child would decide if the child were capable of making such decisions and represent the child in that manner. As the child develops capacity, the attorney then begins to take direction from the child. So this bill, in response to the appointed attorney, also amends the appointment of that guardian ad litem, and it makes this appointment optional. So it allows the court to appoint a guardian ad litem upon the filing of the petition or any time thereafter. So the section would no longer then require this appointment, hence why I've said the word optional 3 or 4 times already. And it also takes out the part where if there's a disagreement between the child and the guardian ad litem, the current law requires the guardian ad litem to inform the court of the disagreement, and that could lead to an appointment of a second attorney. So this bill, with that first appointed attorney and then a potential guardian ad litem, removes that aspect of that second attorney, or in the position, would be a third attorney. So additionally, in order to implement this change of this newly appointed attorney, the bill amends multiple statutes that relate to the representation of the child in those child in need of care proceedings. So I will run through those as quickly as I can. So first, it amends the definition of a court-appointed special advocate. The current definition states that a court-appointed special advocate does not include a guardian ad litem, and this bill clarifies that the CASA does not also include that newly appointed attorney. So in numerical order, this also amends 382211 to include a child's attorney as a person who may access the child's official and social file. 2212 is amended to allow this attorney to have access to agency records, so DCF records. 2219 is amended to allow the child's attorney to motion for an evaluation and a written report of the psychological or emotional development needs of the child in which they are representing. 2229 would include a child's attorney as a person who has a privilege or a right of confidentiality. So if they are subpoenaed, they may, in writing, request for the court to squash that subpoena. In 2236, it would require the summons and a copy of a petition when filed to be served to the child's attorney. In 2247, it would prohibit a court from excluding the appointed attorney in adjudications or dispositional proceedings. In 2248, it would allow a child's attorney to stipulate or enter into no contest statements. 2249 would allow the child's attorney to be present during testimony, and currently many are not allowed to ask the child specific questions if the child chooses to testify. And so this appointed attorney would be granted the ability to do that. In 2258, it would require the notice of any change in placement of the child. If the child has been in the same placement for more than 6 months, that notice of that change be given to this appointed attorney. Additionally, in 2260, which governs proceedings and orders relating to placement and change in placements, the bill would require this appointed attorney to attend certain hearings, and when the court enters certain orders, and that when notices are sent, they are also sent to this attorney. 2268 would require the appointed attorney's participation in proceedings related to the voluntary relinquishment. So there are examples where the parents of the child relinquish their parental rights directly to the secretary. So that includes this appointed attorney in that process. 2275 would allow for the court to fix fees for these attorneys if this attorney takes up an appeal for the child. So if the attorney continues representation into the appeals process, this allows the court to fix fees for such attorney. And lastly, 2291 require that when a child is placed in a qualified residential treatment facility, that notice is sent to multiple different people. And so this just amends that one of those people include that appointed attorney.
Any questions, committee? Representative Carmichael.
Thank you, Mr. Chairman, and thank you, Ms. Pringle, for the comprehensive briefing. Can you explain to us, hopefully in layman's terms, what the difference between appointed counsel as contemplated in this bill is as compared with a guardian ad litem? to the extent explaining what the differences and their responsibilities are, and maybe even if you're familiar with the ethical concerns, just give us a little help with that if you could, please.
Sure, Representative. Currently, the statute, when it comes to a guardian ad litem, says that the person shall make an independent investigation of the facts upon the petition is based and shall appear for and represent the best interests of the child. So this committee is fairly familiar with what best interests of a child means. That doesn't necessarily mean what that child wants or their choices. So that factor-based best interests of the child is the guiding principle for a guardian ad litem. A guardian ad litem is under law also required to be an attorney. And then this appointed attorney is different in the fact that they are representing and counsel for the child in a way that they confer with the child on what the child's desires are, what they want to happen in the court, what they would prefer their placement to be, rather than a best interest staffing situation where you have a caseworker, the GAL, and multiple people inputting on generally what is this global best interest of the child. So those are going to be the two differences between what this proposed attorney would do and what the guardian ad litem currently does and would continue to do if this bill passed.
And I appreciate and agree with that explanation. But one additional factor, at least as I understand it, and I do not practice in this area of the law, is that a guardian ad litem, in a sense, works for the court or reports to the court, whereas counsel, as contemplated here, is actually an advocate for the child to carry out, to the extent possible, the child's wishes and desires. Is that generally correct?
Correct.
And the attorney-client relationship, I believe, would apply to the child or to the attorney contemplated by this bill, whereas a guardian ad litem typically does not actually have an attorney-client relationship with the child. Rather, the guardian ad litem shares the information that the ad litem has with the court without concerns of privilege. Is that generally correct?
Representative, so I would say the current statute in the bill is silent as to what that attorney-client relationship looks like between a guardian ad litem and a child. But if this attorney, this appointed attorney, is in fact representing the child, then they would have that attorney-client relationship and heed those ethical guidelines.
Thank you very much for your assistance. Thank you, Mr. Chair.
Representative Lewis. Thank you, Chair. I think my question better suited for conferees that are going to talk about the bill. Very good. Any other questions for Jesse? Okay, thank you. Proponents, Darcy Olson.
Good afternoon, Chairman Patton, Vice Chairman Schreiber, and Ranking Member Carmichael, and all of those of you I've been able to meet today. I appreciate your time, and those I haven't, I still hope I will get a chance to meet you. My name is Darcy Olson. I am the founder and CEO of the Center for the Rights of Abused Children, and I'm obviously providing testimony in support of House Bill 2381. But before I get started, I want to say that one of the most important things about me to know is that I have fostered 10 of the children that we're talking about today. And I've adopted 4 of them. And I don't know yet whether they're going to be Republicans or Democrats because they range in age from 6 to 11, but they are all diehard Chiefs fans. So they were all on board with me coming to Kansas today to help other kids like them. And I'm really happy to be here. I appreciate you hearing me today. So about 10 years ago, I felt inspired to become a foster parent. And in my home state of Arizona, just like in Kansas, there is a shortage of families to take in the children. So they asked me if I would take in one of the newborns. And like here, we have a lot who have been drug exposed. And so, you know, there were a lot of challenges I expected as a new parent that we all expect as new parents. Complications from withdrawal. I expected the convulsions, the shaking, the seizures, the all night long feedings, the constant visits to the pediatrician, the sleepless nights, and I was prepared for all of that. But what I did not expect was that to best care for this baby, I would have to hire a law firm to represent her interests in court. Now, this is the Judiciary Committee. And I would like to tell you that the American legal system made every effort on behalf of this child, that the focus of the process was on Anne's rights to life, liberty, and her safety. But that was not the case for my first child, my second, my third, all the way to my 10th, nor is it the case for children in Kansas or the vast majority of children in this country. Now, as I sat at the back of the courtroom with this abused child, not even having a seat at the hearing, I thought that had to be a mistake. Anne's parents were provided with attorneys. The Child Protection Agency, or DCF, that placed her in foster care was represented by a team of attorneys. And even the judge had an appointed legal advisor, a GAL. The only person in this situation who was not entitled to an attorney to protect her rights was the abused child, who spent 3 weeks in the NICU fighting for her life before coming home. Now, this flies in the face of everything that we believe in, especially in the judiciary, any notion of justice, of due process, or equal protection. Now, it is my belief that a child should have the right to an attorney from the time they are from the moment of state involvement, just like the criminally accused, and for the same reasons. And the reason that the criminally accused have a constitutional right to counsel in this country is because their lives and their liberty interests are on the line. And that is very much the case, perhaps even more so sometimes for these children who have been abused. These proceedings that they go through will determine whether they ever see their parents again. If they have been wrongly taken, will they go home? If they need to be protected from situations of incest, will they be? Whether they will see their siblings, whether they will be adopted or age out of the system. These proceedings, importantly, also determine whether these children literally live or die. One of the facts that is true in Kansas, as it is true across the country, is that half of all of children in our country who die from abuse are known to DCF. They have open cases or previously open cases, and they are killed anyway. And one of the reasons for those high death rates among children who are on the radar screen is because they have no advocacy in the courtrooms that will determine the outcomes of their futures. Now, I recognize that in Kansas, as in many places, including my state, that you have guardians ad litem, and there is some measure of protection there, but a guardian's duty is to the judge and to the court. It is not a duty to the child. They are working advisors. They are not lawyers for the children. They have no obligation to advocate for the legal rights of that child. And in addition, the research on this is extremely clear. In the states and places where children have attorneys versus guardian ad litems or no representation at all, they exit the system up to 3.5 times faster than children who do not. And we all want kids to get home sooner, or to get adopted sooner, or to go to relatives sooner. There's no one in this room who thinks kids should be lingering in the system. So that speed with which counsel can make these cases move is critical to these children's futures. Children in Kansas spend more time in foster care than they do on the national average. You have more children aging out than the national average, and your wait times are also longer than average. And you can fix this. And this is the committee that can do it. And of all the problems that these children face, and that list is long, the kids are aging out, we're short on funds, we don't have enough social workers, the kids are going missing. Of all of the things that you could do to protect children in foster care, to ensure they have a chance in this world, maybe the same chance even as our children do, is to give them an attorney who will give them a fighting chance in the cases that will determine their futures. I'd be happy to take your questions. Thank you.
Questions, committee? Representative Heiberger.
Thank you, Mr. Chair, and thank you for being here. I appreciated our conversation earlier. And you answered one question that I asked that might be useful for a committee. I received an email from a judge I really respect, who is really concerned about the ability to find enough attorneys to meet the requirements of this bill. It was in a smaller community. They're already having to find GALs from counties and counties away. And could you tell me the answer to what my question was?
I appreciate that question. So if just to restate what that is that there is a concern that there won't be enough attorneys for some of these kids, especially in the rural areas. Our proposal is that the people, the men and women who are currently serving as guardians ad litem in the state, have the opportunity to become the actual attorneys for the children. So the same attorneys that you have now, who basically have a duty to the court, would be the same attorneys that you have serving the children. So if you have a shortage now, you'd have a shortage in the future, but if you don't, you wouldn't. But I also say one thing that's really important is this is not static. So we know that when these children have attorneys, they will get out of the system 3 times faster. So what that really means is you're going to be freeing up the time of attorneys to work on more cases over time. And then finally, I would just say, kids' lives are on the line. So if we need more attorneys, let's hire them.
Representative Munn.
Thank you, Mr. Chairman. Ms. Olson, thank you for coming. This question is going to sound impertinent, and I don't mean it that way. I'm just trying to figure something out. How much time have you actually spent in the child need of care system in the courtrooms here in Kansas?
Well, I think you know the answer to that. I'm not a foster mother in Kansas.
Because I think statistics don't always do justice to what's actually going on in the courtrooms. I just I don't know to what extent your center maybe had come around and done some studies or stopped in. So I was just curious about that.
Sure. I appreciate that. And I would just like to say, I'm not, just like a person from Arizona. Your foster children are my foster children. They come from the same backgrounds, have the same problems, and you actually have an almost identical system to the one that is in Arizona. But the studies that have been done are national, and the change that we're asking for to give children counsel is supported by the American Bar Association as well as the National Association of Counsel for Children. So, some things, such as the constitutional right to an attorney when you're the criminally accused, apply everywhere because those are basic liberty interests, and we share those as Americans. So whether you're in Kansas or whether you're in Arizona or California, if you are a child in need of care, you need an attorney in your case.
Thank you, ma'am.
Representative Buchanan.
Thank you, Mr. Chair. Thank you for being here and coming all the way from Arizona. We've got an oversight committee that's been, looking for the gaps in our system, and the guardian ad litem has been something that just really stands out as very inconsistent across the state. And one of the big issues was that they'll not even know the child or meet with the child. And we've been trying to figure out a way to connect the dots with who they should be answering to and who we can have some authority. How could this change that system?
I appreciate that question, Representative Concanon. So I have read those stories, and in my written testimony, provide a number of examples of parents and other folks involved with the system talking about how the guardian ad litems do not know the children in their care, often don't show up for court, and things like that. The big change is that when you are counsel for children, many of you are attorneys, and you know this, you have ethical obligations to your client. And the bar oversees your work. And so that's just a different level of accountability and responsibility that you bring to the role. But at the same time, I want to be fair to the guardians ad litem in this state. They work very hard. Their job is not to serve as counsel for the children. Their job is to be an information officer for the judge. And that's what they do. So the criticisms are true, but it's not necessarily because they're not doing their jobs. Sometimes they're doing their jobs exactly the way the job is written.
We just have maybe the wrong expectations. So, thank you, Mr. Chair.
Representative Smith.
Thank you, Mr. Chair. And mine comes actually from a situation that she's referring to that I'm dealing with in mine. I don't deal with child in need of care at this aspect, so I'm having a bit of a problem understanding the relationship, and perhaps this is a question for Jesse or Natalie on the relationship between the child's attorney and the guardian ad litem. If there is a decision that they disagree on, what trumps it? Is that a decision of the court, or who actually makes the decision in those cases?
You want me or someone? Was that for someone else?
I'm asking the revisers, but if you know the answer to it.
So I do. Do you want me to take it? Okay. So you're asking, what if the child wants something that might not be in their best interest? What happens?
No, I'm sorry. I'm asking if a guardian ad litem and the child's attorney disagree on how to proceed. Who trumps who?
Well, it's up to the judge.
Okay.
Okay.
I need to know. Thank you.
Other questions? Representative Susan. Can Cannon go ahead?
Thank you. Sorry, I jumped in front of you there. For a second question. Now if I talk long enough, maybe I'll remember what my question was. Does every child, when they have their own attorney, will they have a guardian ad litem?
The guardian ad litem would be optional. So the attorney could ask for guardian ad litem, the judge could ask for a guardian ad litem, but the counsel will be mandatory. So it's just a flip. Today, they all get GALs. A counsel is at the discretion of the judge, and this would be the reverse. So they would all have counsel, and then if they needed a GAL, that would be at the discretion of the judge. I just want to add to that point. Children may have a diminished capacity to exercise their rights, but they don't have lesser rights, except right now in these courtrooms. And so that's what we're trying to remedy. And these attorneys know full well how to deal with children or clients with diminished capacity and have been well trained for that.
Thank you. Thanks.
Representative Humphreys.
Thank you, Mr. Chairman. I have two, I think, related questions. You mentioned that, we know that children in Kansas have waited over 3 years on average before being adopted. And then you said in states that have implemented this 3.5 times faster. So what does that mean by months? Or what do you mean 3.5 times faster?
So it's exiting for permanency, which could be a return to home. It could be I'm living with grandma, or it could be a stranger family like mine. And it means, so 3 times faster. So if you're in care now on average, say in Kansas for 3.5 years, that you would expect to see that to go down to about 1.5 years, which is actually what the federal guidelines and rules recommend, and that you guys blow out every year. Not just you. I'm not saying you. It's everywhere. And the big problem is not having an advocate in the courtroom for the kids.
Yeah, I mean, permanency, that's awesome. But could you explain why is that? So like, what is the attorney doing that the guardian ad litem could not be doing?
Well, the attorney is fighting for the rights of the child. So for instance, there are federal laws and state laws about how long you're supposed to be in care, when a TPR should be filed, when a change of placement should be filed, all sorts of things like that. Those things are not in general happening on time here or in most places anywhere. And the reason for that is when you go in the courtroom, you have the biological family attorneys fighting for them, and they want the cases to last as long as possible for their clients, and they're doing right by their clients in that. You have DCF that has attorneys, and they are not looking to speed up these cases either, because they want time and care as grounds for the next step, because it's objective and you don't have to prove it, and it's quite easy. So this team and this team will both ask to delay the next hearing by 6 months or 9 months, even though, for instance, report and reviews are supposed to be every 3. So what we've seen is the attorneys will come in and they will make sure that those hearings happen and that these cases move on time. And if you're supposed to file a TPR when you have grounds, they will file the TPR.
Which is what?
Sorry, a termination of parental rights.
Yep.
Or it could be a change of placement. It could be time to go home and they're lingering in a foster family and they maybe be there an extra year and they need to get home. So that's what the studies on this show, that regardless of what that outcome is, that permanency plan happens faster for those children.
Okay, great. Thank you. Thanks so much for being here.
Representative Carmichael.
Thank you, Mr. Chairman. I appreciate your advocacy and your passion for this issue. I know that you're here doing what you believe would be the best thing for Kansas children. And I think, as you know, though, I don't see the situation perhaps the same way that you do. But you have made repeated reference here to some state or some locale which has adopted this type of a program and reduced the time of the pendency of these proceedings by by 2/3, I believe. Can you help me, because I couldn't find which article that you cited in your written testimony stands for that proposition? Could you point me to the correct citation?
So I don't have my written testimony in front of me, but I believe it is in there and I can definitely get it to you after. There are 2 big research reports. One comes out of Palm Beach in Florida and one comes out of Washington State. So we can certainly get those to you and to all the members of the committee.
I think that I've looked at those citations and I just guess I wasn't able to reach the same conclusion that you did. Secondarily, I've been looking at the testimony of Mark Lazo, a lawyer in my hometown who has extensive experience in this field. And in his opposition testimony, he points out that the lawyers that you contemplate would be obligated ethically to do what the child wanted. And he gives examples such as the child could direct his attorney that I don't want therapy. I don't want drug treatment. I want you to increase my visits, send me home. I want you to make a motion to change my placement. I don't want you to disclose that my parents communicate with me outside of visitation times. And the point that he makes, at least in his testimony, is that under the scheme in this bill, the lawyer for the child would be obligated to advocate for what the child wants, even if it's not in the child's best interest. Who advocates under your scheme for the child's best interest, realizing that children of tender years their desires are not always in their best interest?
I think that's a great question. And I think the judge is in some ways on point. It is true that the counsel needs to talk with the child and listen to the child. And the child may want something that someone else doesn't think is in their best interest. But at the end of the day, what you're really talking about here is whether that child will have a voice or will not have a voice. It's the judge who determines the best interests of the child. So the parents get a voice, the state gets a voice. Right now, the child does not get a voice. We think the child should have a voice. But at the end of the day, it is the judge who determines best interest for the child.
I may have heard incorrectly, but Mark Lazo is no judge. I will assure you of that. He's a well-qualified lawyer, though. But I'm not following. Well, first, under the existing law in Kansas, when the guardian ad litem discovers that there is a difference of opinion between the child's desires and the guardian ad litem's opinion of what is in the child's best interest, that the guardian ad litem has an obligation to go to the judge, inform the judge of the conflict, if you will, that the GAL thinks the child's desires are not in the child's best interest. And then the judge has the discretion to appoint counsel for the child to make those arguments while the GAL continues to represent the best interest of the child. What's wrong with that procedure that we already have?
Well, I mean, I think what's wrong with that procedure that you have right now is that children are suffering and they need to get out of the system a lot faster than they are. And we know that if they have counsel, they will. So I think the proof is in the systems as they operate. And right now, you know, you're cheating the local children here and could be doing a lot better by them by giving them a voice in the courtroom. Under the system that we're proposing, the judge can still appoint a GAL if the judge would like someone else to help determine what they think is in the best interest of the child. But someone has to fight for the rights of that child. I don't think anybody in here would want their kid in the courtroom with anything less than an advocate or anything less than you would expect for yourself. So that's what's wrong with it.
Perplexing. I look forward to receipt of the literature that you referenced. Thank you, Mr. Chair.
Representative Heiberger.
Thank you, Mr. Chair. This is a follow-up to my question and Representative Kirkanian's question. I believe from our conversation, you told me that under the new system with the children having an attorney in Arizona, that there really aren't very many guardian ad litems being appointed. Is that accurate?
Yes, there are no studies on it yet because it's only been about a year and a half, but we do also run a pro bono law clinic for kids in Arizona. So we're in court every day and we are seeing not too many appointments of GALs, but we do see them. And some judges really like that. And that's wonderful. More coverage is better in my opinion.
Do you have any idea how that compares to the number of attorneys being appointed back when kids had GALs?
I'm sorry, I don't get the question.
Previously, children had GALs and had the option for an attorney.
Oh.
Yeah, how those numbers compare?
I do not.
Thanks.
Representative Munn.
Thank you, Mr. Chair. Ma'am, the bill has in it a provision that says if the child is, and this references something you brought up earlier on, but if the child does not yet have capacity to say what their best interests or what they want, that the attorney is then supposed to decide what that child would want. How do you propose that would work with a 1 or 2 year old?
So there are a lot of great attorneys in this room who might be able to answer this better than I can. But, you know, my understanding is that they use substituted judgment and that we do this all the time with people who have diminished intellectual capacity or other challenges. And there's a whole ethical canon written for that. The other part I think that's getting lost here is we keep talking about what the child might want or might not want. We're thinking of, like, you know, the 14-year-old who's misbehaving or something. I think the most important piece of this is that children right now, these guardians do not have an obligation to fight for the rights that child has. So all of the laws that you're passing to protect children in foster care, they're not worth a lot unless someone is in the courtroom advocating to enforce those rights. So I think that's very important, and that's really the larger role of counsel, as well as using substituted judgment or conferring with the client.
Okay, follow up, sure. So if I substitute my judgment, wouldn't I then just be, I mean, you'd assume that your judgment would be what's in the best interest of the child, and that you would assume that the child would want what's in their best interest. I mean, that's how rational people behave, right? We decide what's in our best interest. So if you've got a child who's not yet at capacity, the attorney would simply do exactly the same thing as the GAL does.
So I think what the attorney would do that the GAL doesn't do is to make sure that the laws and protections that we put on the books for foster kids and a particular child in that case would be followed. That's their job so they're filing motions, they're taking care of all kinds of proceedings. So I mean, I kind of think you're playing around with words a little bit, because it's a tremendous difference between council and the way that GALs currently operate.
I'm really not. I'm trying to figure out how I substitute my judgment for somebody who's a child and doesn't have the capacity, and we don't know what that person's personality and what they're going to want is. And so,
So we could send you the professional code of conduct that Kansas has established for attorneys in this space, and be happy to send it. It's pages long about how to do substituted judgment. So I can definitely furnish that to you.
I'm capable of finding that myself, but it just, there are parts of this bill that just seem to be almost nonsensical, because you're having the only real way to substitute my judgment for a baby would be to do what's in the best interest of the baby, and that's I'm just not getting it, I guess. Thank you.
Other questions, committee? Very good. Thank you.
Thank you.
Committee, we have written proponent testimony from the Children's Alliance of Kansas, the National Association of Counsel for Children. Are there any other proponents? If not, we have a neutral conferee, Judge Hogan, on WebEx.
Good afternoon. My name is Kelly Hogan. I'm a district court judge in Sedgwick County. I also serve as a member of the Kansas Supreme Court Task Force on Permanency Planning. Prior to taking the bench almost 3 years ago, I worked in child in need of care courts across the state. The bulk of my 23 years of experience is as a guardian ad litem, the attorney who, under the current law, represents the best interests of the child. As a judge, it's my job to follow the law as written. Judges determine the facts of the case and apply the law to the facts. I'm not here to say what the law should be. That's the legislature's job. I'm here to provide information about how a change in law would impact the court. House Bill 2381, if passed, would result in a significant change to child in need of care proceedings across the state, as it directs the court to appoint an attorney for the child. Currently, the court appoints an attorney for the child who acts as a guardian ad litem. A guardian ad litem is an attorney who conducts an independent investigation, makes recommendations to the court regarding the best interests of the child, and is obligated to inform the judge of all information that the judge needs to determine best interests. Under the current rules, the guardian ad litem is required to determine the child's desires and present those desires to the court. The court has the authority to appoint an attorney to represent the child in addition to the guardian ad litem if the court finds the positions of the guardian ad litem and the child are widely divergent. In child in need of care court, the judge must make decisions which the judge finds are in the child's best interests. Judges rely on the child's guardian ad litem to independently investigate and make recommendations so the judge can then make decisions based on the child's best interest. Each child in need of care case currently has attorneys representing the state, each parent, possibly grandparents or other interested parties. Those attorneys must consult with their clients and argue for the client's position, regardless of whether the attorney feels the position is in the client's best interest. Like any other attorney-client relationship, the client, or in a child in need of care case, the child, would direct the attorney's representation. Many cases involve infants or young children who are not able to articulate the objectives of representation to an attorney. House Bill 2381 does state that a court-appointed special advocate, or a CASA, may make a recommendation regarding best interests of the child. This occurs under current law. However, not every district has a CASA program, and many times CASA programs do not have enough volunteers to serve every child. If the court delays proceedings in order to wait for a CASA to be appointed, this could delay permanency for a child. Additionally, Attorneys acting as guardians ad litem have different ethical obligations in carrying out client representation. A guardian ad litem makes recommendations as to the child's best interest. In contrast, an attorney has an absolute duty of confidentiality. That attorney may only disclose information to the court that the client authorizes the attorney to disclose. Even if the lawyer knows the judge would want to know the information, the ethical rules do not allow the attorney to disclose the information without the child's permission. For example, under the current law, if a child tells his or her guardian ad litem that he or she is using illegal drugs, the guardian ad litem will inform the court so that the child can be assessed for drug treatment. If the child was represented by an attorney instead of a guardian ad litem, that attorney would not be able to provide that information to anyone unless the child agreed to the disclosure. Additionally, if an attorney is representing an infant, the attorney is left guessing what the infant prefers. I also have attorney resource concerns about House Bill 2381. Under the current law, judges appoint one guardian ad litem for each family. In cases with siblings, a judge may appoint an additional guardian ad litem if a circumstance arises where siblings' best interests are in conflict. However, those situations are rare. If the judge appoints an attorney for the child, the attorney's ethical obligations will not allow that attorney to represent more than one sibling in any family. There is already a statewide shortage of attorneys practicing in child in need of care court. If a judge must appoint an attorney for each sibling, many counties won't have enough local attorneys to represent parents and siblings. I'm happy to stand for questions. Thank you.
Any questions, committee? Representative Carmichael.
Judge Hogan, pleasure to see you. Unfortunately, I have a tickle in my throat at this moment, so I'm not breaking out in tears, but excuse me. As I recall, prior to your ascendancy at the bench, what it's been now, 3-4 years ago?
Almost 3 years in April.
Time flies. This was an area of law which I think you devoted a substantial part of your career. Is that correct?
That's correct. 23 years of my entire attorney career of 23 years, I worked in child need of care court.
And I understand, of course, that you're testifying as a neutral conferee on this bill. But it would be fair for me to ask you, based upon your years of experience practicing in Kansas, as well as your time on the bench, would you recommend that this committee adopt this legislation?
Well, Representative, I think you know as a judge, it's my job not to determine what the policy ought to be, but to apply it to the facts. So I just don't think it's appropriate coming here today as a judge to make that determination. I did point out in my testimony the concerns that I would anticipate.
And hence you testify here today as a neutral, as opposed to a proponent or an opponent. Is that correct?
That's correct.
And I do understand your circumstance. I'm sorry to put you on the spot. Thank you, Judge. I appreciate your work.
Representative Schreiber.
Thank you, Mr. Chairman, and thank you, Judge. The previous conferee talked about, I guess, a more rapid placement when an attorney was used for the child. I'm just kind of curious what your experience has been.
My experience is that the attorneys that we have working in juvenile court as guardians ad litem take their obligation to the best for the best interest of the child very seriously. We do have regular continuing education, and it's without a doubt that the sooner that a child can achieve permanency, either by returning home to their parents or through some other means, the better. I don't think the guardians ad litem neglect their obligation to the best interest of the children just because their role as guardian and not as attorney.
Any other questions? Okay, thank you, Judge. Committee, we have written neutral testimony from the Kansas Association of Counties and the Kansas District Judges Association. Any other neutral conferees? Okay, opponents. I have two listed, both on WebEx. The first is Mark Jordan.
Hello, committee. Thank you for the opportunity to speak here this afternoon regarding House Bill 2381. I've provided written testimony. I just really have a few comments to make. I've been listening to the questions that have been asked, and I just listened to what Judge Hogan had to say. I've actually practiced with Judge Hogan for many years, both when she was a GAL, and I've also appeared in front of her as a judge. And I share many of the same concerns that she has shared here with the committee today. I think the current statute strikes the right balance. I think GALs play a critical role in this process. All through these proceedings, courts need to make decisions concerning the best interests of these children. And I believe that that having a guardian ad litem is important. I share Judge Hogan's concerns about the different relationship between the attorney and the child. Because this lawyer actually would represent the child, all the rules of confidentiality would apply, all the rules of conflicts of interest would apply. And it's just a fact that in many of these cases, we're dealing with groups of siblings, not just one child. And there's going to be, many times there's going to be conflicts. And because of confidentiality, each one of these children is going to need their own lawyer to represent them. Whereas, as Judge Hogan indicated, one GAL may be able to represent an entire sibling group. We're going to have to appoint a lawyer for each one of these kids. I don't know where these lawyers are going to come from, and I don't know who is going to pay for this. But it is going to be quite costly, I would imagine. I also think, as I think one of the questions that was asked earlier talks about the ethical implications this creates for these lawyers that represent these children. As someone indicated, this lawyer would have to argue if the child wants to go home with the parent. They would have to vigorously make this argument, even knowing that if that child would return to the home at this time, they could be in danger. It could be a very dangerous situation for them. This lawyer would have to make that argument anyway. Even if they knew it could be very detrimental or harmful to their client. I think the current statute strikes the right balance, as has already been indicated, in certain situations where the interest of the child and the best interest diverge, the court has the authority to appoint that second lawyer. It's been my experience that the GALs are very good about informing the courts when that's the case. They let the court know what the child's wishes are and what they think is in the child's best interest. And so I think we really have the best of both worlds here. I don't really see any reason to change the statute. CASAs also oftentimes will provide a voice for the child. We have those here in Sedgwick County. We have access to therapy reports. And so we can get information on what these children are actually saying to their therapist. And so I think we know what these kids want. I think their voice is heard. Oftentimes these kids will actually come to the court proceedings themselves and have an opportunity to talk to the judge about what they want. So I think we're doing things the right way right now. I'm concerned with this bill. I don't think it's necessary, and I'm available to answer any questions the committee has.
Thank you. Any questions, committee? Representative Lewis?
Hi, I'm an attorney, but I don't practice in this area, but I've been thinking about this. If I were put in the shoes of either the guardian or the attorney appointed, but one thing you just said made me pause. You said that where there are multiple children in a family, the guardian ad litem is appointed one, and there's conflicts. And the guardian ad litem just continues to plod along with the conflict. I mean, it just grates at my sense of being an attorney and representing my client that I would operate with a conflict, which I guess guardian ad litems just do it. But that bothers me, that the system would have a person, attorney, representing a group of people where there are conflicts. Could you answer or respond to that?
Well, I've always, I mean, I think the rules are a little bit different for guardian ad litems, the ethical rules as compared to a lawyer that actually would actually represent the child. Um, because of confidentiality, the guardian ad litem has the ability to let the judge know um, about the conflict. She can advocate for all the children typically at the same time. I think with a private attorney though, they would, if they had a conflict, they would have to or someone that's representing the child would have to get, they'd probably have to get off the case because they'd have confidential information about both children. And at that point, they probably would have to get off and couldn't represent either one of these children. And so what would happen, I think, with a lawyer that was appointed to represent a child is if there was a conflict, I'll be honest, I'll be frank, some of these cases, we have children that are making allegations against the other child. And so oftentimes, if a lawyer has information that, for instance, I've been abused by my sibling, now that lawyer would have to get off the case completely. We'd have to appoint two new lawyers to represent both of those children. I hope that answered your question.
So in that hypothetical, you're saying if we had lawyers, are you in the hypothetical you just told us about? Are you assuming that there's a guardian ad litem or multiple attorneys, or one? Are they playing the role of the guardian ad litem or the attorney?
I think what's going to happen in Sedgwick County, if this legislation were to pass, is the judges here would continue to appoint guardian ad litems, and so we'd have both guardian ad litems and a lawyer representing the child.
Right, and I guess what I'm hearing is that probably would be best, but we don't have the resources for that.
I don't know. I'm not saying that would be best. I'm saying what I'm saying is that, well, yes, I don't know that the resources are there, but I think because most of the courts here rely on guardian ad litems, I think they would continue to appoint those even if it was discretionary.
Thank you.
Representative Titus.
Thank you, Mr. Chairman. So on May 10th, the Kansas News Service published a story detailing the guardian ad litem system in Kansas. The headline described the system as failing. And if you read the story, that seems fairly accurate. I remember hearing that on the story and actually researching how I might become a guardian ad litem if I were going into private practice, because it was so alarming listening to how many children are not having their best interests represented. And hearing your description of the system paints a very different picture. So I'm struggling with how to reconcile what you're saying about how guardian ad litems work and the actual state of the system our children have to deal with.
That's a fair question. I mean, I can only tell you what my experiences are as a prosecutor in Sedgwick County. I've been doing this for about 10 or 12 years now. And it's been my experience that the guardian ad litems take their responsibilities very serious. They're very diligent. As I've indicated, it's very common for a guardian ad litem to let the judge know both what the child wants and what they think is in the child's best interest. I've never felt that children don't have a voice. I think everybody takes what's in the best interest of these children very seriously. And I think courts rely on guardian ad litems a lot to help them make these decisions. This entire code is driven towards what's in the best interest of these children. And I think guardian ad litems play an important role in that.
So to push back on that a little bit, though, and unless the article's taking a very narrow sample, it suggests there's a lot of guardian ad litems that may not even meet the children before they're making these recommendations to the judges, or they may meet them only one time very briefly, and family members are concerned that these people may be professing what they believe to be in the best interest of the child, but that they don't take the time to really figure that out in an objective way. Are you suggesting you don't ever run into attorneys that are not spending the appropriate time to determine the child's best interests, or that just doesn't happen in Sedgwick County? Or again, just trying to reconcile the narratives here.
I mean, I might have to defer to the guardian ad litem. I can't say with certainty that every single guardian ad litem in every case is fulfilling their responsibility. But in general, I think they are. And I think they're talking to the children when they can. As has already been indicated, many of these children are pre-verbal and they don't have the ability to communicate with their GAL. But I think as a whole, it's been my experience that most of these guardian ad litems take their responsibilities seriously.
Representative Humphreys.
Thank you, Mr. Chair. Thank you for being with us. Can you tell me how many times, maybe in the last year, have judges appointed an attorney in addition to the guardian ad litem in our sink cases in Sedgwick County?
Sure. Fair question. It's very rare.
It's very rare, you say?
It's very rare. It's very rare for an attorney to be appointed in addition to a guardian ad litem.
Mm-hmm. And then my other question is, and I have a limited experience practicing in Sedgwick County in that particular area, but how often would you say guardian ad litems are filing motions and asking the judge for different timelines and to look at different things and placements, and how active would you say the guardian ad litems are in actually having pleadings to the court?
I would say typically these matters are not done through the guardian ad litem filing formal written pleadings. It's typically done through oral motions during our in-court reviews. And that's typically how they do it. But the guardian ad litems, I think, are fairly diligent in trying to achieve permanency for these children as quickly as possible.
Yeah, thank you. And the last thing I'll just mention is your testimony mentions that it's a solution to a problem that we don't have, but if we're above the national average in permanency for kids, and it's 3.5 years or 3 years and 2 months is on average before kiddos who are available for adoption are adopted, I would say that is a problem. And I am interested to know, how we can shorten that timeline and how kids can achieve permanency faster. And that's why I'm interested in this bill. But thank you for being with us.
Thank you.
Any other questions? Okay, thank you, sir. Next, Caitlin Eakin, also on WebEx.
Hi, committee.
Hello.
Hold on 1 second. There we go. Sorry. Thank you, Chair and members of the committee, for allowing me to speak today. I am Caitlin Aiken. I am the State Director for the Kansas CASA Association. I have been in this position for about 2 years, but previous to that, I spent 6 years as a local program director in Great Bend, Kansas. And so I just wanted to share a couple of my experiences in the courtroom there in a more rural frontier area of our state. So a big thing that I saw at the beginning of each case in the assignment of attorneys was a lot of conflict of interest, because we do not have a large amount of human resource capacity in the attorney field in our area. And so a lot of judges or a lot of attorneys wouldn't be able to take on certain clients, whether it was the mom, the dad, or even as a GAL for the child, because of a conflict of interest in a prior hearing. So that's something that was very prominent in our area. The other thing that I would like to add is that as a local program director for CASA, I would see many times a GAL speak specifically to the child's best wishes, as far as saying, this is what the child would like. However, upon speaking with the social worker, speaking with the CASA, the therapist, the teacher, whomever that GAL needed to speak with, they would say that they believe that, this course of action wasn't in the child's best interest. And so I just wanted to share those two experiences that I had at a local level. But I predominantly want to say that the Kansas CASA Network fully supports legal representation of a child in a child need of care court proceeding, and that we fully support Statute 382205 that outlines the assignment of a required guardian ad litem attorney to represent the child's best interest in proceedings, with the option to add a secondary attorney if the child's position is not consistent with the guardian ad litems. And now I know that doesn't happen frequently, but it would keep the child's best interest top of mind. So there are two essential differences between a CASA volunteer and a GAL attorney in the state of Kansas. GALs are assigned to every child as current language states, and they must be an attorney. So a GAL in Kansas undergoes similar training as a CASA volunteer in the context of education regarding child's best interests, child welfare issues, cultural awareness, mental health, substance abuse, adverse childhood experiences, and child development. And that was all taken from Rule 110A, which outlines the duties of a guardian ad litem. Hold on, I lost my place. CASA's model for the appointment of a GAL attorney and a CASA volunteer is similar to some other states, but each state really has their own model for when it comes to a child representation and advocacy. And so in Kansas, we do have a requirement for legal representation for children in a proceeding with that assignment of a GAL. So we're really testifying here today that children in need of care in a child need of care court proceeding have a statutorily required best interest legal representation. The Children's Bureau and the Child Welfare Information Gateway help define guidelines for determining best interest of a child. These guidelines, based on requirement in the Child Abuse Prevention and Treatment Act, federal, recognize the necessity of having statutorily required best interest representation, which is currently authorized in our Kansas statutes. Further, first focus on child initiatives goes into greater detail about ensuring that government policies safeguard the rights and holistic needs of children. I did outline many questions that the CASA network has. We're really more, inquisitive opponents of this language change. We want to understand it more before we can say that this would be, perceived best interest or not. We just really are not sure of unintended consequences. And so that's why we are presenting this here today. So one question that I did not ask in my written testimony that I should have is, if a GAL isn't informing the judge about what the child's best interest, who is going to do that? Because the language change says optional GAL CASA. And as I stated, a CASA is not assigned to every case, and many others have testified to that before me. And so statutory indicates that a judge must make a best interest finding here in Kansas. So my other question would be, who would then, if there's not a GAL assigned and there's not a CASA assigned, who would represent that best interest? And again, just the human resource issues that we face out in, rural frontier communities of Kansas. CASA alone has 20 local programs, and of those 20 local programs, the counties we serve in each of those programs, 73% are in more rural frontier programs. So we of course want children to have legal representation, and we want children to have a voice in the courtroom. We just want to make sure that due diligence is done to ensure that it's done in the best way possible. So I stand for any questions at this time.
Thank you. Committee, any questions? Don't see any. Thank you very much.
Thank you.
Committee, we have written opponent testimony from Michael Lazo. Any other opponents? Not seeing any. I will close the hearing on House Bill 2381. Committee, we're going to try to work a couple of bills. I promise we're not going to be here very long.
I have an amendment.
Well, let's start with We'll start with one that's probably going to take the longest, and we'll see where that goes. 2215.
Thank you, Mr. Chairman. House Bill 2215 creates the crime of utilizing a drug masking product, and it provides criminal penalties for violation of that crime.
Any questions for Natalie? Are there amendments? Representative Osman.
Thank you, Mr. Chairman. I have an amendment. I'd like to make a motion to introduce the amendment.
Yes. So, yeah, we'll have Natalie and Kathy get it distributed if you want to go ahead and explain it.
Sorry, I don't have it up exactly in front of me. However, the amendment itself is very, very simple. It takes the definition as to what specifically we're looking to do as far as a drug masking product, and sort of separate that out into three different components. It doesn't change what those drug masking products are, but the basic focus of it is it changes the word or to and. We were having discussions in the original hearing that, haha, what if we're banning water? What if we're banning pickle juice? And I'm looking at the amendment and saying that might be a possibility based on this definition. And so I just wanted to clarify that. So by changing used or to used and, I think that we get rid of that situation.
Okay. Would you like to make your motion?
So I'd like to make a motion to approve my amendment.
So is there a second? Representative Curtis, discussion? Oh, you probably don't have it yet. Well, I do. So check your email. Hit refresh. There we go. And now it's on the screen as well for those that have better eyesight than me.
What line is that on?
So it's at the bottom of page 2, lines 32 through 36. Everyone had a chance to read it? So quiet. The and is now at the end of the second. Oh.
Mr. Chairman, I think that, based on what Representative Osmond was talking about, I think that the and that you'd want to be looking at is in the very first line, any of the following when used and designed to be used for the purpose. Yep.
Multiple ands. Okay, any discussion? Seeing none, you can close.
I close my amendment.
You've heard the motion. All in favor say aye.
Aye.
All opposed say no. Motion carries. Any further amendments? Okay, not seeing any. Is there a motion concerning House Bill 2215 as amended? Representative Smith.
Thank you, Mr. Chair. I'd move that we pass HB 2215 as amended.
Seconded by Representative Concanon. Any discussion? Representative Carmichael.
Thank you, Mr. Chairman. I think there's something wrong here with this bill. And what leads me to that conclusion is there is one and only one proponent. And that proponent is one of the largest drug testing companies in the United States, if not the world. If this was something that really needed to be done and was advisable, I would have expected the line to be out the door and down the hall of proponents. I would have expected, for example, the Society for Human Resource Management to have been here explaining to us what a problem this is. I would have expected perhaps people from the KBI's laboratory to be here. I would have expected Kansas law enforcement to be here. I would have expected the workers' compensation insurance carriers who can disqualify workers for benefits on the basis of urinalysis testing to be here as well. I don't think that there is an outcry in this state for what the one testing lab asks. And I think the natural advocates, if there were in fact a problem, are conspicuous through their absence here. And if we do find next year that there is a line out the door of people who say, yes, we need to do this and here's why, then we may want to take a look at it. But I really don't think that we should pass this type of legislation based upon the request of one out of literally tens or hundreds of testing laboratories. Thank you, Mr. Chair.
Representative Heiberger.
Thank you, Mr. Chair. I didn't have a chance to fully process the Osmond amendment before we voted, so I can't make a motion to reconsider, but I'm going to express my concern with it and see if anybody else wants to make it. Sorry, Jen. What the amendment says is it applies to any of the following when used and designed to be used for the purpose of defrauding an alcohol or drug screening test. One of those things is human urine of another person. I don't think human urine of another person is designed to be used for the purpose of defrauding an alcohol or drug screening test. So I would encourage reconsidering this.
Representative Carmichael.
I think the representative's point is well founded, and I'm sorry too. But I think having voted in the affirmative, I think we are entitled to proceed with a motion to reconsider, and I think I would make that motion.
Is there a second? Second by Representative Vaughn. Discussion on the motion to reconsider.
Maybe we could get a revisor's opinion.
Yeah, Natalie, any thoughts on that? Not on the policy, but Representative.
Thank you, Mr. Chairman. Let me make sure that I understand. So the reason, as I said, I'm fine if we want to either roll it back or modify it in some way. As I see it, so human urine is of another person. If it is used or designed to be used if it's used and designed to be used to defraud these drug screening tests, that is when, in this particular situation, it would be banned because I guess let's open it up. How would we better phrase that?
Changing the and back to or, but I mean that doesn't correct the problem you were designing. I mean, I think the way it's written now, then human urine of another person would not be a drug masking product because it's not designed to be used for the purpose of defrauding an alcohol test. Maybe that's okay. I mean, I don't mind excluding that because I don't really like the whole bill, but.
Representative Titus?
Chairman, perhaps a qualifier on human urine of another person and some sort of qualifying statement to that when used for the purposes of defrauding. That way it kind of circumvents the design part.
Representative Lewis?
Thank you, Chairman. I think Representative Titus has a good point. You would have to find that if there's a synthetic urine, it was used and designed, or if it was a substance designed to add to human urine, hair, or oral fluid, it would have to be used and designed. But if it's human urine, it would just have to be used for that purpose, right? I think that solved the problem. What's that?
However, you might clearly say that, yeah.
Let's Representative Heiberger, or either one of you. Yeah, Heiberger first.
I suggest maybe instead of designing this now, maybe we can see if the bill gets enough votes to pass out of committee before we waste a lot of time on it.
Representative Humphreys.
So if the representative could Could you explain? I mean, when you said the pickle juice, I'm like, yeah, we talked about that. But now I'm not understanding what was wrong with, where would that fit in before, if you don't mind, while Natalie's working on that?
Sure. Okay. So as I read the amendment, or as I read the original uh, document itself, it goes through a number of different sort of commas and pauses and clauses. But if we were to take most of it out and just say used, not designed to be used, but because it's used, or you can take all the rest out and say, if something is used um, for whatever means. And so if you have something that is used, wouldn't water be that? Wouldn't pickle juice be that? Wouldn't mouthwash be that? And that was my concern as I read through this definition of drug masking product.
Representative Smith, and I'll come back to you, Representative Hyberger.
Thank you. I had a couple of things, and I'll address this one first. I think the way I read these when they're structured that way is I take out any of the following and I replace it with whatever the line is. So I would say human urine of another person when used and designed to be used for the purpose of defrauding, or synthetic urine when used or designed to be used. And when you do that, it makes perfect sense. But instead, we put it as a list. And I think it clearly states, I think the word design, right? When something is by design, created or used by design, it's not necessarily how it is manufactured, but rather how it is employed. And that's the way I did stand back when I first read that and tried to read it again. So I understand the confusion on, but I don't think that it's so confusing that it can't be meted out. Oftentimes I think the law, when it lists like this, and you have to go back and say, well, does it say and or? And as the list, is it an exemption or is it an inclusion? I'm constantly having to do that on lists like this. So that I think that's the same thing you have to do here. On the point that Representative Carmichael makes about the one laboratory giving testimony, I mean, I think one could easily argue that they are the subject matter expert in our state for this because of the number of tests and because of the volume that they are asked to test in their laboratories. They're absolutely going to be our canary in the mine that tells us what's going wrong. And we've got to react to that when those experts say, hey, we've got a problem. And this is not the only subject matter we've ever passed out of a committee on the back of one expert who was able to give us enough. This is almost one of those things where we're arguing about whether or not somebody should be able to defraud a urine test. That's what we're arguing about right now. And we don't have enough experts to tell us that people defrauding urine tests should have a law against them. I don't think that question comes here requiring more expert testimony to tell us that defrauding these things put the public at risk, put our safety at risk, put our health at risk through a number of the type of material that we're trying to outlaw here is pretty complex. It sounds silly, but it is. It's pretty complex. They're trying to imitate something at a high cost. And if we don't get ahead of this game, they're going to get way out in front of us. So that's what I'd say about that. Thank you.
Representative Hyberger.
Yeah, I guess I would go back to Sam. If you look at this more, I don't share the concern of Representative Osmond because of regards to water or pickle juice, the testimony with those things were used by drinking them, not by adding them to human urine, hair, or oral fluid. So I don't think the law was problematic before. But I think if we do it the way it's amended, then one, human urine is not going to be, because criminal statutes have to be construed strictly in favor of the defendant. So a court looking at this is going to say, well, it was used to defraud an alcohol test, but human urine wasn't designed to be used. I think you can see the same thing with water if you were actually adding it to human urine. Well, water wasn't designed to be used to defraud a drug test, nor was pickle juice. So I think the amendment really isn't necessary and causes a lot more confusion. But again, I didn't vote, so I can't move to.
Let's go to Natalie for a second.
Mr. Chairman, I think I might have something along the lines of what you guys have been discussing if you want me to share it. Not that Representative Osmond, would necessarily want this version of the amendment, but I can.
Why don't you share? We're still on a motion to reconsider.
Right.
So go ahead and share so we know what we might be reconsidering for.
Mr. Chairman, essentially what this one would do, which there's an errant semicolon at the end I've just noticed, but it would, instead of the 3 elements of that list, you would just have 2 elements. The first one would be synthetic urine or a substance designed to be added to human urine, hair, or oral fluid that is designed to be used and is used to defraud an alcohol or drug screening test, or human urine of another person that is used for the purpose of defrauding an alcohol or drug screening test. So the designed portion would be removed from the human urine element.
Representative Heiberger.
This question for the riser. Do you not believe that a substance added to human urine, hair, was the substance designed to be? Okay, never mind.
Okay, now that you have this in your inbox and you're able to consider it, we're still on the motion to reconsider. Any further discussion on that? Yes, Representative Lewis.
I'm just asking what that motion exactly means. If it passes, does that mean we go back to the beginning where we were? Or does it mean that we go to something Natalie just proposed?
Phone a friend really fast to make sure I don't mess this up. So if we pass the motion to reconsider, we would then reconsider the amendment. So we would take it up for vote, or we could vote it down or consider a substitute motion, which could be the one in your inbox. So any further discussion on the motion to reconsider? Seeing none, Representative Carmichael.
Thank you, Mr. Chairman. I close and move my motion.
For the motion, all in favor say aye. All opposed say no. Motion carries. So now we're back on the amendment of Representative Osmond. Is there any discussion on the amendment that was previously made? We're now reconsidering. So you're going to vote again on that. So you can either vote yes, no, or you could make a substitute motion. Representative Smith.
Well, I guess I'll make a substitute motion for the new amendment.
Got it.
A second.
Seconded by Representative Osmond. So now we're on the substitute motion. Any discussion? Seeing none, you can close.
I close.
All in favor say aye. All opposed say no. Motion carries. Now we're on the bill as amended. Is there a motion? Any further amendments? Is there a motion concerning the bill as amended? Representative Lewis makes a motion we recommend favorably as amended.
I do.
He does.
Motion.
Is there a second? Representative Smith seconds. Any discussion that we've not already had? Seeing none, you may close.
Close.
Heard the motion. All in favor say aye. All opposed say no. No votes wanting recorded. Carmichael, Heiberger.
Vision. Too late. All right.
Okay. Did you get that, Kathleen? We're gonna stop. We'll stop here, guys. We have Monday and Tuesday, which who knows if that'll be enough. But so from today, we still have 2216, 2351, and 2395. This list is subject to be smaller or larger, but be paying attention to 2121, 2246, 2293, and 2326. Yes, Representative Heiberger.
Sure, what just happened? Did we finish the vote? And if so, I'd like my vote recorded.
That's all happened and recorded.
All right, thank you.
Correct? I didn't miss anything, did I? Oh, I didn't? Oh, is that why you called division? Okay, that motion carried. Okay, let's redo that. We'll just do it for the sake of doing it. So we're voting on the bill as amended, Representative Lewis's motion. All in favor say aye.
Aye.
All opposed say no. Motion carries. No votes wanting recorded. That's where I jumped ahead, didn't I? Carmichael and Heiberger vote no. Now we're done for the day. The bills again, 2216, 2351, 2395, 2121, 2246, 2293, and 2326. Again, subject to change. If you're not going to be here Monday and you've not already told me, I would appreciate knowing. Not that that will change things significantly, but I want to make sure we have plenty of people here. So that's it. We're adjourned. Thank you.